Welcome to our discovery of the freedoms of religion, privacy, and criminal due process, encouraging community and civic engagement. This is part one of 2 parts of the video. The script and the quiz, however, are all together. The Constitution's framers understood that the government they were creating could use its powers to single out certain groups for either favorable or unfavorable treatment, and in that way could interfere with the creation of community, and with citizens' engagement within the community. The founders' commitment to community building and citizens' engagement lies at the heart of several constitutional amendments in the Bill of Rights. Specifically, these are the amendments establishing the freedom of religion, the right to privacy, and the right to due process for individuals in the criminal justice system. The religion clauses of the First Amendment, the Establishment Clause and the Free Exercise Clause, essentially do 2 things. First, they bar the government from establishing or supporting any one religious sect over another. And second, they ensure that individuals are not hindered in the exercise of their religion. Whereas the Establishment Clause requires that the government be neutral toward religious institutions, favoring neither one specific religion over others, nor all religious groups over non-religious groups, the Free Exercise Clause prohibits the government from taking action that is hostile toward individuals' practice of their religion. As we now consider, there is tension between these 2 clauses. Stating only that Congress shall make no law respecting an establishment of religion, the Establishment Clause does little to clarify what the relationship between church and state should be. The Constitution's authors wanted to ensure that Congress could not create a national religion, as a number of European powers, notably France and Spain, had done. The framers sought to avoid that level of government entanglement in religious matters. Further, many colonists had immigrated to America to escape religious persecution in Europe, and although many were deeply religious, uncertainty prevailed about the role of government should play in the practice of religion. That uncertainty, too, is reflected in the brevity of the Establishment Clause. The question arises, does the clause prohibit the government from simply preferring one sect over another, or is it broader, encompassing any kind of support of religion? This is a crucial question, because religious institutions have always been important forums for community building and engagement in the United States. Americans continue to be a very religious people. In 2009, over 81% of Americans surveyed said religion was fairly or very important to their lives. But even given their strong religious affiliations, most Americans believe in some degree of separation between religious organizations and the government. The actual debate has been about how much separation the Establishment Clause requires. Over time, scholars and lawyers have considered 3 possible interpretations of the Establishment Clause. One interpretation, called separationism, is that the Establishment Clause requires a strict separation of church and state, and bars most or all government support for religious sects. Supporters of the strict separationist view invoke the writings of Thomas Jefferson, James Madison, and others that call for a wall of separation. That term is oftentimes used on the AP in conjunction with Thomas Jefferson in the First Amendment. That call for a wall of separation between church and state. They also point to societies outside the United States in which religious leaders dictate how citizens may dress, act, and pray as examples of what can happen without strict separation. A second and more flexible interpretation allows the government to offer support to religious sects as long as that support is neutral and not biased towards one sect. This interpretation, known as neutrality, or the preferential treatment standard, would permit government support provided that this support extended to all religious groups. The third interpretation is the most flexible and reads the Establishment Clause as barring only establishment of a state religion. This interpretation, known as accommodationism, allows the government to offer support to any or all religious groups provided that this support does not rise to the level of recognizing an official religion. Which of these 3 vastly different interpretations of the Establishment Clause is correct? Over time, the Supreme Court has shifted back and forth in its opinions, usually depending on the kind of government support in question. Overall, the courts have rejected the strictest interpretation of the Establishment Clause, which would ban virtually any form of aid to religion. Instead, they have allowed government support for religious schools, programs, and institutions if the support advances a secular, which means non-religious, goal and does not specifically endorse a particular religious belief. For example, in 1974, the court upheld a New Jersey program that provided funds to the parents of parochial school students to pay for bus transportation to and from school. The court reasoned that the program was necessary to help students to get to school safely and concluded that if the state withdrew funding for any of these programs for parochial school students, it would be impossible to operate these schools. The impact would be the hindrance of the free exercise of religion for students and their parents. In another landmark case, Lemon v. Kurtzman, 1971, however, the court struck down a state program that used cigarette taxes to reimburse parochial schools for the cost of teacher salaries and textbooks. The court found that subsidizing parochial schools furthered a process of religious teaching that the continuing state surveillance that would be necessary to enforce the specific provisions of the laws would inevitably entangle the state in religious affairs. In the Lemon case ruling, the court refined the Establishment Clause standard to include 3 considerations. So this is a 3-pronged test. Does the state program have a secular as opposed to a religious purpose? Secondly, does it have its principal effect of the advancement of religion? Thirdly, does the program create an excessive entanglement between church and state? This 3-part test is known as the Lemon test. The programs most likely to withstand scrutiny under the Establishment Clause are those that have a secular purpose, have only an incidental effect on the advancement of religion, and do not excessively entangle church and state. More recently, the court upheld an Ohio program that gave vouchers to parents to offset the cost of parochial schooling. The justices ruled that the purpose of the program was secular, not religious, because it was intended to provide parents with an alternative to the Cleveland public schools. Any aid to religious institutions, in this case mostly Catholic schools, was indirect, because the primary beneficiaries were the students themselves. Finally, there was little entanglement between the church and state, because the parents received the vouchers based on financial need, and then were free to use these vouchers as they pleased. There was no direct relationship between the religious schools and the state. So where the government programs offer financial support, the court has tended to evaluate this program by using either the preferential treatment standard or the accommodationist standard. Whether the program or policy involves prayer in the schools or issues related to the curriculum, however, the court has adopted a standard that looks like strict separationism. This table summarizes the court's decisions in a variety of school-related free exercise and Establishment Clause cases. The ones that you need to know off of this list are Lemon v. Kurtzman, Everson v. the Board of Education, Zellman v. Simons-Harris, Engel v. Vitale, Lee v. Weissman, Santa Fe District v. Doe, Zork v. Clausen, and Agostini v. Felton. Make sure you write those down. As this table illustrates, a series of cases began with Engel v. Vitale in 1962, has barred formalized prayer in the school, finding that such prayer has a purely religious purpose and that prayer is intended to advance religious as opposed to secular ideals. For that reason, the court has barred school-organized prayer in public elementary and secondary schools on the grounds that it constitutes a state endorsement of religion. Student-organized prayer is constitutional because the state is not engaging in any coercion by mandating or encouraging student participation. Recently, courts have begun to grapple with the decision of some school boards to mandate the inclusion of intelligent design in the curriculum. Intelligent design is the assertion that the apparent design in the universe and in living things is the product of an intelligent cause rather than of an undirected process, such as natural selection. Though not stated by its primary proponents, many supporters believe that the designer is God, and they seek to redefine science to accept supernatural explanations. Advocates of intelligent design claim that unlike creationism, which defends a literal interpretation of the biblical story of Genesis, intelligent design is a scientific theory. For that reason, they say, school boards could be permitted to include it in the curriculum alongside evolution. Opponents claim that intelligent design is just another form of creationism because it is based upon a belief in a divine being, does not generate any predictions, and cannot be tested by experiment. Mandating that schools teach intelligent design, critics argue, constitutes an endorsement of religion by the state. The tension between the Establishment and Free Exercise Clauses arises because the Establishment Clause bars the state from helping religious institutions, whereas the Free Exercise Clause makes it legal for the government to enact laws prohibiting the free practice of religion by individuals. Establishment Clause cases often raise free exercise claims, and so courts must frequently consider whether by banning state aid they are interfering with free exercise of religion. Although free exercise and establishment cases raise many of the same concerns, they are different kinds of cases, whose resolution depends on distinct legal tests. Establishment Clause cases typically involve well-established and well-known religious institutions. Because Establishment Clause cases often center on state aid to religious schools, many involve the Roman Catholic Church, which administers the largest number of private elementary and secondary schools in the country. In contrast, Free Exercise Clause cases tend to involve less mainstream religious groups, among them Mormons, Jehovah's Witnesses, Christian Scientists, and the Amish. These groups' practices tend to be less well known or more controversial. For example, Free Exercise Clause cases have involved the right to practice polygamy, to use hallucinogens, to refuse conventional medical care for a child, and to refuse to salute the flag. The Supreme Court has refused to accept that the government is barred from ever interfering with religious exercise. Free exercise claims are difficult to settle because they require that the courts balance the individual's right to free practice of religion against the government's need to adopt some policy or program. First and foremost, the court has always distinguished between religious beliefs, which government may not interfere with, and religious actions, which government is permitted to regulate. For example, although adults may refuse life-saving medical care on the basis of their own religious beliefs, they may not refuse medical procedures required to save the lives of their children. In assessing those laws that interfere with religiously motivated action, the court has distinguished between laws that are neutral and generally applicable to all religious sects, and laws that single only one sect for unfavorable treatment. In Employment Division, Department of Human Resources v. Smith, 1990, the court allowed the state of Oregon to deny unemployment benefits to 2 substance abuse counselors who were fired from their jobs after using peyote as part of their religious practice. Oregon refused to provide benefits because the 2 men had been fired for engaging in an illegal activity. The court concluded that there was no free exercise challenge because Oregon had good reason for denying benefits to lawbreakers who had been fired for their jobs. The justices concluded that the state was simply applying a neutral and generally applicable law to the men as opposed to singling them out for bad treatment. One consequence of this case was that several states, including Oregon, passed laws excluding members of the Native American Church who smoke peyote as part of traditional religious rites from being covered by their controlled substance laws. In summary, people are free to hold and profess their own beliefs, to build and actively participate in religious communities, and to allow their religious beliefs to inform their participation in politics and civil society. However, individual actions based on religious beliefs may be limited if those actions conflict with existing laws that are neutrally applied in a non-discriminatory fashion.